Hello, welcome back to our mini-series. Council tax, statutory demands and bankruptcy petition service. Remember, the elected councillors will have no idea of the council's policy as most are officer-led, but they will remember to give the council their bank account details for their allowances. They may not be so quick to help you. When it comes to holding their council officers to account, please refer to previous videos. You have every right to ask them to witness what is happening in the courts and to make sure their council staff and agents are acting correctly and to hold them to account if they are not. That is their job, especially after the council have misappropriated your funds and used them towards a previous, already secured debt. The council will serve a statutory demand personally using a council process server that could be instructed by outside solicitors. Why not use their own in-house officers? Surely this would be more cost-effective. Is it because they do not wish any wrongdoing to link back to the council, even though they are still liable for any actions of their agents or officers? We already know that the court are allowing the council to file 2 petitions into a case instead of 1. It is crucial that you record the council process server serving a statutory demand and the bankruptcy petition in multiple ways: photographs, videos, CCTV, etc. If possible, make sure that you are not alone and have a witness to any incorrect service. If they cannot serve you with the documents personally, they will send you a letter with an appointment date and time and must give you 2 days clear notice if you are lucky. Now comes the clever bit. They could turn up early or late or not at all, which is why you must record them. Some even pretend to try your gate or bell and to speak with your neighbours. The statutory demand will be put through your letterbox, and they might, at a later stage, make out that you have avoided service. They know that the court will not question anything and will ignore any evidence produced when you challenge the service at the statutory set-aside hearing. Just because the court may ignore the evidence does not mean the public will, so record everything. Isn't it interesting that process server only have to give a statement of truth rather than swear an affidavit, which could carry a sentence of up to 7 years for perjury? The council are also required to file a certificate of service, but you may find at the statutory demand set-aside stage hearing no certificate has been produced. At this stage, the judge should throw the case out, but will they? Of course not. Would the same favour apply to you if you broke the insolvency rules? They will try the same tricks at the petition stage, but will need to apply to the court for a substituted service. You may find that the judge who made the order for substituted service could not have made an order, for example, because no judges were sitting. Of course, all these discrepancies will be put down to administrative errors and the records recreated. the judge will simply say, "You are here now, aren't you?" at both the statutory set-aside hearing and the petition hearing, and will ignore the evidence that does not favour the counsel. Now, would the counsel process server need to get around serving the documents properly? Why would he do that? Is it because a bankruptcy petition has not been filed and registered correctly? I'll leave you to think about that one, and we should be back very soon with the next step in exposing what's going on, how it should be done, and what they are actually getting away with doing.